Morning. Please be seated. This is the time set for oral argument in Wilcox against BNSF. Our cause number is 1CA CV 15-0740. Counsel, I know you're aware that we have fully reviewed the briefs and record in preparation for today's argument, and you can bear that in mind as you begin your presentations. We will be audio and video recorded today, and those recordings will be made available online to the public in the next couple of days. Each side has 20 minutes for oral argument, and the appellant free to reserve as much time as you wish, but you need to do it yourself by watching your own clock. And with that, if you're ready, we can begin.
Thank you, Your Honor. I guess I'd like to reserve 2 minutes. My name is Bill Thorpe. I represent BNSF Railway Company. The FELA is a statute whereby railroad workers who are injured during the course of their employment can file a federal negligence action seeking to recover compensation from their railroad employer. This is a case that, this FELA case is one that really involves fairly straightforward issues of negligence and comparative negligence, and should be looking at the behavior of Mr. Wilcox and his coworkers on the evening of the accident. The reason BNSF is entitled to a new trial in this case, however, is that despite the relatively straightforward nature of the accident and what should have been the liability claims, the trial court permitted plaintiffs to interject into the case 3 legally barred liability theories that were improperly before the jury and deprived BNSF of a fair trial. Those 3 theories were, first, a purported negligence per se claim involving a legally inapplicable ACC regulation, Rule 110.
Why is it legally inapplicable?
It's legally inapplicable for multiple reasons, Your Honor. First, there is some guidance relating to the interpretation of this regulation from another decision from this court that we've cited to you for persuasive value called Winkler versus BNSF. And an look at that statute, that regulation, discloses that as applied, any walkway identified by that regulation must be off of the track and the supporting track structure.
But Winkler seems to be a very different case. First of all, the accident there occurred on a walkway. We have, in this case, an undisputed fact that there was no walkway.
Your Honor, first, Winkler most assuredly was not on a walkway, and that was what the Winkler court found. It was the accident did not happen on a walkway by definition. And the point from Winkler that's relevant here is that the court looked at 109, which looks at track and track structure, and the language in 110, which requires any walkway to be off of the track and track structure. The track and track structure here extends far beyond the location where Mr. Wilcox was walking. And so it's simply any walkway that would have been identified by that regulation would have been off of the track structure and off of the ballast that is apparent in the photographs that we submitted to the court in connection with our briefing. Second, it's inapplicable because Brian Lehman, who is the head of the Rail Safety Division of the Arizona Corporation Commission, pointed out that that regulation is meant to do 2 things: define specific areas where walkways are supposed to be located, specific areas where certain kinds of activities take place. For example, rail yards where people break and put together trains, or industrial leads where loads come in and things are unloaded and taken away. And
that testimony, though, dealt with only one paragraph of the regulation. And that was a paragraph that actually addressed, I believe, ballast composition in those certain heavily trafficked areas.
That's correct. And what he said was that regulation applied only to certain locations. For example,
that
yards
paragraph applied. Well, I don't believe that there's any testimony, and frankly, I'm not sure that testimony is in any way dispositive of a legal question. But I don't believe there was any testimony that said the entire regulation applied only to those heavily trafficked areas.
Your Honor, that testimony was in connection with what the phrase trackside duties was and where trackside duties are performed. And he defined that phrase, which is the entirety, prefatory language for the entire regulation, as meaning specific duties in specific locations. So yes, his testimony was that this regulation did not apply to the duties that were being performed at that.
So you're suggesting that what Mr. Wilcox was doing was not a trackside duty?
Was not a trackside duty as defined by the as that phrase is used in the regulation.
Well, as that phrase was used by the witness. The phrase in the regulation contains no definition, and I always thought it was the court's job to interpret the law. I'm always befuddled when we have former Supreme Court justices or administrative officials come in and tell us what they think the law means, because that's a fundamental legal function of the sitting court, is it not?
It is, Your Honor, although there's deference, and the cases that we cited to the police board case that we cited and others to the court suggest that there's deference that you should be giving to the interpretation, particularly something where you're looking at a railroad regulation, you're looking at the head of the agency that not only promulgated the regulation but enforces the regulation as to what it means. And I think at a minimum that it's entitled to persuasive value, if not deference, in that.
But you're not suggesting that this was an unusual. It's not within the typical gambit of duties required of someone like Mr. Wilcox. The train didn't stop in an unusual place. Changing out crews isn't necessarily unusual. It seems hard to not categorize it as a trackside duty.
Well, the issue, though, is what's the meaning of the regulation in terms of where walkways are supposed to be under that regulation. And if the focus
wouldn't the logical interpretation they would be required where you might be expected to be performing trackside duties?
Well, Judge Catani, that's exactly the point, because the evidence at trial was, and the truth is that everywhere there is a track, we can expect railroad workers to be on the track at some point in time, because all of this track is maintained. It is inspected 4 times a week. People go, so workers, not only people getting on enough trains, but other people employed by the railroad are on that track on foot all the time, on all of it. So that if the rule were, if we can anticipate somebody is going to step down at this location or walk along this location, either as they're doing maintenance work or while they're doing track work or while they're doing train work, then it's everywhere.
Maintenance work seems very different than getting on and off the train. If this is a spot where you contemplate getting on and off the train.
But, Your Honor, in terms of what the people are doing is walking along the track. It is all the same. With how they got there is a matter in a moment, I would think.
Well, but it's not just walking along it's not just walking along the track. I mean, they were, in this case, directed to stop the train, tie down the train, untie the train, swap crews. This is a more than just checking to see if a spike is properly hammered in. There's an actual train operation that takes significant amount of time and the work of multiple employees being done. It's not maintaining the track, it's operating the train. Isn't that different?
It is a different rail operation. It doesn't necessarily require any more people than, for example, a track gang doing work. And it's a absolutely typical thing to happen on any portion of track where a train crew may die on the law, as this one did, and that need to be have a replacement crew go to that location. There is nothing unusual about the nature of this procedure or the location of this procedure.
But there were specific areas, if I understand the record correctly, where BNSF typically had these dog catches occur. Right. There were designated areas to do this. It wasn't simply a question of, well, your time's up, let's stop the train wherever it happens to be.
No, that is an overassessment of the record, then, Your Honor, because this was a standard move for this train
At a standard place.
Well, at a place where, on occasion, other train swaps had occurred. But remember, the evidence was also that this is a highly used. This is the main transcontinental line of BNSF Railway Company. There are 35 to 40 trains per 8 hours going across here. So this is a very highly used rail line. So it's not unusual that every once in a while somebody's going to stop at a variety of places all over. And that was a testimony. But let's get back to the issue of whether 110 even applies. The number one thing that suggests, if there's any suggestion that 110 should in some fashion result in there be the construction of a walkway on this at this location, then that is just simply preempted by federal law. And that's under 20106A2 of the Federal Rail Safety Act. And that preempts anything that, any state regulation that would interfere with an area that is subsumed by federal regulations.
Does it interfere with it if it just promotes, is consistent with the federal safety standards? How does it contradict any federal safety standard?
Your Honor, the dispositive case on this is a case called Nichols, which is a Court of Appeals case, and it addresses that point. You don't need conflict. It is just preempted. So long as the area is subsumed by federal regulation, you don't need under 20106A2. There doesn't need to be a conflict between the state regulation and
Conflict's a bad word, but if they've suggested that it's okay for the states to come up with some additional safety regulations, doesn't that go against your argument of preemption?
And here, didn't the Federal Railroad Administration expressly say we're not going to promulgate walkway regulations? We want the states to do it.
No. Well, there's no statement by the FRA that it wants states to promulgate walkway regulations. What is true is that there are no walkway regulations under the FRSA that impact track structure or the construction of the track. That is all covered exclusively and preempts anything by the federal track safety standards, which covers rail and track. And that's exactly the holding of Nichols and a host of cases that we have cited to Your Honor, to the court, relating to whether whether these federal regulations preempt walkways that are supposed to be on the track structure. And there are multiple cases right down the line, starting with Nichols, that say that no, that is preempted and you can't do that. That's exactly within the express.
Are you saying that a walkway can't be constructed without compromising the support structure of the rail?
What I'm suggesting to Your Honor is it can, so long as sort of consistent with what the Winkler Court was a little bit adverting to. And the Winkler Court itself said this is probably preempted in a footnote 2. It can, so long as it is off the track structure. And for example, in this case, there was a dirt area just to the north of the two sets of tracks that may have met the definition of a walkway under that. And it did not impede on track structure, and it did not run afoul of anything that was precluded by Nichols or any of those cases.
Right. Nichols seems to me to apply to track structure. It applies to actual issues concerning ballast, which are the subject of federal regulations.
Exactly.
Walkways are not the subject of federal
Right.
regulations.
Right. So long as those walkways are away from the ballast, off the ballast, that's okay. But my point is the claims here was that somehow you either have to change the location or put some sort of walkway on the existing structure, and that's precluded, period. Our other issue was excuse me?
What is the best case for that? Because
Nichols
doesn't say that. Nichols talks about the composition of the ballast. It doesn't talk about the existence of a walkway on the ballast.
Nichols, if you look at Brenner, Sanchez, McCain, and Norfolk versus Burns, those are all cases we cited that talk about you can't intrude on the walkway structure. You can't intrude on the track structure, and that makes sense though, because I mean, you're starting to deal with issues of track stability. You're starting to deal with issues of track drainage. you're dealing with all kinds of things when you start messing around with what the federal government, under the federal track safety standards, says you have to do in terms of building the track.
Are you saying that the railroad on its own would have been precluded from building a walkway, even if it wanted one, that it's precluded from doing so?
I am not saying that the railroad cannot do it. I am saying that it is complied with the federal standard of care if it builds it in accordance with the federal regulation. And that insulates it from liability on that issue. If you look at 20106, it refers to the regulations that are promulgated by the FRSA as being the federal standard of care. This is the Federal Employers Liability Act. I don't see anything inconsistent with saying that if you comply with the federal standard of care in a federal lawsuit, that you satisfied your duty. And so when we're talking about preemption and preclusion here, that's exactly what we're talking about. We have complied with the federal standard of care when we comply with the regulations as to the things that are under attack that we've identified here.
Do you think the regulation was preempted?
Excuse me?
Did your witness think the regulation was preempted?
I don't know that the witness was asked that question, Your Honor.
But you have the state promulgating these regulations.
Yes.
That on the one hand you say we owe deference to the agency in interpreting, but on the other, the record is silent on whether the agency thinks they even have the authority to promulgate them.
Well, and parenthetically, Your Honor, there's a difference between saying they would be preempted if used at this location, or whether they would always be preempted if they call for, as I've indicated, a walkway that is not on the track structure. That's different.
Let me make sure I understand one of your arguments. You're saying that the dirt area that it was away from the ballast constituted a walkway consistent with the federal regulations?
I said that it could constitute a walkway under the Arizona regulations because there are no federal regulations relating to walkway.
But you're saying it met the standard of care under the federal regulations? So therefore, that the railway had met its duty and cannot be liable? Is that?
No, Your Honor, and Judge Kessler, I'm obviously not doing a good job of explaining myself. What I am saying is that under federal law, this walkway regulation does not apply because it's preempted. Okay? I'm also saying that under the interpretation that the Winkler court said, it can't be on the track structure either. Both of those things are in harmony, which puts it in some place other than on the ballast.
Right. So you're saying a walkway, like a dirt area, away from the ballast,
yes,
would be sufficient?
I agree with that. And here's the kicker.
Even though, could he perform his duties in untying the cars if he was walking on the dirt road, the dirt area?
He could not get on a rail car and do it, but the point of the walkway is not to be able to reach from the walkway and do the work on the car. The walkway is to provide access up and down the track in an area where you're not going to be hit by the train, not where you can do the work on the car.
So he was in essence being told to walk on the ballast and the track to untie these cars. And you're saying, and that met the standard of care under the federal regulations.
Yes. Because
you couldn't have a walkway there. All you had to do was have a walkway across, away from the track.
I'm not saying that at all, Your Honor. I'm saying that it was a reasonably safe condition for him to work at that location as it was configured with the ballast, but that if there needed to be some compliant walkway with the Arizona walkway standard, then that condition existed to the north of the tracks, and that it complied with both what the Winkler court said is necessary.
He couldn't have done the job that he was required to do of untying the cars if he was on that walkway.
He could have crossed back and forth every time he needed to do it. Yes, and he would have been out away from the track. The problem with that one was that the trial court judge ruled as a matter of law that that wasn't a walkway. They took that away from us as the issue, despite the fact that that was, according to the Winkler court and according to federal preemption, the only location in that area that could have been, because it wasn't on the track structure. So that was another error by the trial court. So I'm going to reserve the 1 minute I have.
Okay.
May it please the court, my name is Taylor Young and I represent Mrs. Wilcox in this case. I'd like to start by addressing a question that Judge Kessler asked, which was about whether or not Mr. Wilcox could have performed his duties, the duties he was being asked to perform that night, from that stretch of road to the north. And you heard counsel concede that he would have to walk back and forth across the track, and there was expert testimony in this case that said it was not reasonable would not be reasonable to require him to walk across all these tracks to that area, then traverse a small portion, and then walk again across the live main tracks in order to untie these handbrakes.
Sorry to interrupt you for a
Please.
moment, but our clock isn't running.
Oh.
No. All right. Is your
For the
clock
court's
running?
benefit, mine is counting down as well.
Then we're going to trust you.
Thank you, Judge Swan. So the notion that it was error for Judge Warner to rule that wasn't a walkway consistent with the regulation, I think is inconsistent with the facts that he had and inconsistent with the purpose of the regulation.
Well, would you say that the regulation, I mean, as we try and envision this physically, would you say that the regulation really requires walkways to be built on top of ballast?
It's not necessary. In fact, there was
In this location, on the facts of this case, would an effective walkway have had to have been built on ballast?
Well, so there's two questions that I want to answer that, but the premise also is that they wouldn't necessarily have to do changes at this location. They could choose a location where they could get a walkway. I think that's important, though, because that's part of the underlying liability in this case.
At the places where you would say changes can appropriately be performed, are there walkways built on ballast?
There's walkways built on ballast all over the place, and including in rail yards. It's not at all uncommon. There are also, in fact, there was a question, and I apologize, I don't have the reference right now, but there was a jury question regarding how walkways could be built, and including a cantilever system where the walkway would exist completely above the ballast. So it's certainly possible to build a walkway, a compliant walkway, without directly impacting the track structure, if that is, in fact, the preclusive rule. We don't concede that it is, but if in fact that was.
Before we get into matters of federal preemption, then, your theory is that in every place where a dog catch can appropriately be performed, a walkway is required by the Arizona regulations.
If they are going to be required to perform trackside duties, and in this case, the trackside duties and what the jury found was that what Mr. Wilcox was doing was a trackside duty, which was walking along and knocking off the handbrakes. But I think it's important for the court to recognize that the railroad didn't have to require the tying down of this train. They could have left the crew on there, which would have been a very different and a very different kind of change, and may or may not have implicated this trackside duties issue. But here, he's definitely got to walk along the train and knock off these ties. And, you know, the question is, why was he walking on the hot side? and he was walking on the hot side because because there was no walkway, and that was the place where it was level to walk. And as our brief points out, there's testimony from other engineers or conductors who said happens all the time, that you have to do that. Sometimes you don't have a choice. His choice was either to walk along a very steep sloped ballast, or walk in the V, also in a sloped ballast, or walk up where it was relatively flat. And he chose to walk where it was relatively flat. So
What if the train were stopped for some other reason, kind of independent of a crew change, that just had stopped 50 miles down the track?
sure.
Presumably, there would be trackside duties that would be performed at that point. If the brakes, if whatever it is that's been set, there's some sort of trackside duty. Is there a requirement that there be a walkway in that location?
No, there's a requirement that there be a reasonably safe workplace for these workers. And I don't necessarily concede that if the train breaks down, that means we're performing trackside duties. Here, we're talking about a crew change. And if a crew change is exactly the type of thing that happens where people are getting on and off the train at a rail yard, so I think it's consistent.
A crew member just got sick out in the middle of nowhere, they need to stop, get him off the train. Would that not be trackside duty at that point?
I don't think that we have a clear. I don't think that is necessarily a trackside duty, and the question is also, can you perform it in a safe manner? I mean, one can imagine.
Don't you need a clear line here to sustain the negligence per se aspect of this case?
I don't think we need the question is whether or not trackside duties encompasses what Mr. Wilcox was doing this night. That's the issue here.
So if the train breaks on a bridge, one of these, very steep drop, and all there is a track, a bridge, and a broken train, somebody's going to have to come fix that train.
I completely agree, Your Honor. Somebody's going to have to fix that train.
And the question is, working environment at that point.
Well, the question is, how do you make it safe? And that's what the railroad's obligation is, to make it safe and to perform it and allow for their employees to perform with reason in a reasonably safe environment. And I don't mean to say that's not this case, but it really is not this case. This case is about a crew change that they decided to make on a voluntary basis. They could have decided to do it anywhere else. They did it in a location where it wasn't safe for Mr. Wilcox to be performing the duties that he was required to do.
And they could have kept the crew on the
Absolutely.
crew on the train.
Sure, they could have kept the crew on the train.
They wouldn't have to tie it down.
Which would mean they wouldn't have to tie it down, so it would have been a relatively easy procedure for the swap to go. And of course, tying it down required, as the court knows from the testimony, required Mr. Wilcox to walk up and down the train. So in terms of the definition of trackside duties, if you're going to choose to do crew swaps here, you need to have a walkway, or don't choose to do crew swaps here. Or don't choose to do them in this way.
Is the line you're drawing that if it's the place where you normally do crew changes, is that where you have to build a walkway?
I think if this is a place where there are going to be this type of crew change, where you're tying down the train, then yes, you would have to have a walkway. And Judge Warner was very clear about this. You know, the theory isn't, and you've seen that the railroad's arguing, you're requiring us to build walkways across all of our tracks. And I think the answer is no. What the regulation requires is that you have a walkway, a compliant walkway, wherever where employees are called upon to perform trackside duties.
What other trackside duties are there? What's the family of trackside duties that you think plain language of the regulation is referring to?
Well, there's innumerable things that happen in rail yards, and I think Mr. Lehman may have testified to this, that are considered trackside, would be considered trackside duties. And that's why where you have walkways as well. In terms of encompassing the family of trackside duties, I think the issue here is whether or not walking up and down and hitting these, untying these brakes is a duty that you're required to comply alongside of the track. I think that certainly counts. One thing that I did want to mention is there was discussion about a maintenance issue, and one of the testimony in the at the trial court was that you can get track and time if you have a crew that's performing maintenance on one of the lines, and that's where a request comes in that we're going to slow down and stop traffic to make it safe because we know people are going to be on the tracks. So that I think also helps distinguish what we're talking about in terms of a reasonably safe environment for the performance of this kind of duties, a crew change, for example. I would like to go back to a point that we make in our brief that I don't think has been adequately addressed by the other side. In fact, they may have waived it, which is that in this case, our negligence theories included a failure to warn. There was ample testimony and ample evidence that Mr. Wilcox, that his death was caused or contributed by their failure to warn, failure to blow the horn, failure to do the lights.
I noticed that, and I guess one question I have is, you still have to deal with the walkway issue, don't you? Because Judge Warner the jury allocated 20% of fault to Mr. Wilcox.
Correct.
Judge Warner did not allocate any of the damages. He awarded all the damages, correct?
The jury, yes, he awarded all the damages because of negligence per se.
Right.
Which the statute says if you violate a safety statute,
Right,
then
and that dealt with the walkway.
right. Exactly. But my point.
But I mean, if you say, well, gee, we had negligence because of failure to warn, you'd still have to deal with that 20%.
You have to deal with the 20%, but that doesn't necessarily entitle them to a new trial where we try all these liability theories. We have an allocation of fault here. We have 3 interrogatories. We have an allocation of fault. I think that
You may not entitle them to a new trial, but if we were going to decide that on gee, there was enough liability based on failure to warn, and that was all we did, then we would have to remand or at least allocate the 20%, right?
you would have to at least allocate the 20%, and that's in our brief. I think we essentially say that this is the issue, but what they're saying is that they're entitled to a whole new trial because of this theory was presented to the jury, and our response, as you know, is that you've got a general verdict,
Right.
and they
But if we don't deal with the other issues, then your client would lose 20% of the judgment.
I think that's fair to say.
Yeah.
Well,
You don't want us to do that, I take.
I do. I know. I wasn't suggesting. And really, where that issue goes to is not necessarily the walkway, as much as the dispatcher liability issue, which Mr. Thorpe didn't get to in his presentation, but I know you've seen it in the briefs.
on the dispatcher, the negligent dispatch issue, was there a requirement that there be an expert? You proffered an expert initially. Is that?
We proffered an expert who testified regarding a number of things, who opined regarding a number of things, including communication issues and dispatching practices. There was a motion in limine. Judge Warner denied their motion in limine, but then at trial decided that our witness didn't have the foundation to testify regarding the dispatch issues, despite the fact that he'd been an attorney for the Federal Railroad Administration. But
forgetting that for a moment, I mean, doesn't the negligent dispatch claim come in a couple of flavors? One of them is if you dispatch someone to perform trackside duties in an area where there is no walkway, that is a negligent dispatch. Or am I misunderstanding your theory?
Well, no, it's not our theory, and in fact, that's one of the points that we raise, is they've characterized this as a negligence dispatch theory. The issue is what was the conduct that the jury required expertise to understand. We cite the McDavid case out of D.C., and the other side points out that sometimes you may need a standard of care expert in a FELA case. They suggest that that's contemplated by the McDavid case. But not in that case. And so the question is, did the jury require an expert to understand that you shouldn't require or that it wasn't reasonably safe to require Mr. Wilcox to perform these duties in this place, that this wasn't reasonably safe to tie down, to have them tie down this train and do the swap in an area where there was no level place for him to walk, adjacent to a main line that had traffic on it under these circumstances. And that's not, as we pointed out, those are not very hard facts to understand. It's almost comparable to if someone was driving a bus and the dispatcher of the bus said, pull the bus over on I-10 onto the shoulder, get out and put those toe boots on all of the tires and walk away. Someone will come and get the bus. It's not very difficult to understand that that's dangerous. That's not reasonably safe. And that's akin to what happened here.
But there are some areas that might require expert testimony, that the warning or the other aspects that were alleged. And do those bleed over a little bit? Is there a question about whether the jury considered that in their general verdict?
Whether the jury considered, help me understand the question.
Other aspects of negligence for which expert testimony might be required.
Well, there was expert testimony regarding those other aspects of negligence. We had experts testifying on the communications issues, on the failure to warn. We had experts testifying on all of those issues. In terms of dispatch, even so, Judge Warner said, and I apologize, there's one of the things that Judge Warner said when he was talking about the preclusion, not allowing our expert to talk about dispatch issues. He says it's close. He's got experience as an engineer, and some of these issues are close, which is why I did not sustain those objections this morning in those areas that were close. And so, but what Judge Warner didn't allow him to testify about, which we asked to, was that a dispatcher, for example, should travel twice a year to review their entire territory so that they understand what the various features are of the territory that they control. Our expert wanted to testify about that. We asked that, and Judge Warner said, no, I'm not going to allow him to do that. I don't think he has the foundation to talk about that particular issue. So in this instance, in terms of any bleed over, there's ample testimony regarding failure to warn. There's ample expert testimony regarding the rules and regulations that apply to railroads, the communications, what types of communications you're supposed to have. There are plenty of things from which this jury could have concluded that the railroad had breached its duty to Mr. Wilcox, particularly under the FELA standard, which is a very liberal standard. Unless the court has further questions.
Apparently not.
Okay, we would ask the court to affirm the jury's verdict in all respects. Thank you.
Thank you.
Thank you. Obviously, very quickly, the initial question was whether they contend that there should be a walkway built at this location. They never really answered that question. The answer is that would be precluded by Nichols. Judge Kessler, you asked me about were there other cases that said deliberately you can't build a walkway on top of the ballast. I may have misspoke in terms of the cases I cited to you, but Brenner versus Conrail and the cases that we cited in our reply brief at 17 through 19, there's a collection of cases that all hold that proposition. You can't build walkways on top of ballast. That's preempted by federal law. Yes, mechanical failure.
You can't ever build walkways on top of ballast.
You can't. if you have a regulation, that a state regulation cannot require that because it's preempted, because that's a
So
federal.
what you're saying is that by its silence, the federal government has effectively said there can be no required walkways on ballast anywhere in the country. That seems like a sweeping statement that could be very dangerous.
Well, that's the judgment of the FRA.
The FRA did not make the judgment that there can be no walkways on ballast.
Well,
The FRA decided to be silent about it.
Correct, Your Honor, but in 20106, the Congress declared that any state laws that are in an area that is subsumed by the FRA regulation, that those state regulations are preempted. That's what it says.
Your point is that there are cases that have interpreted those regulations to say you cannot build a walkway on ballast, period.
Correct.
Is that what you're saying?
Yes, because that affects the integrity of the ballast and the track support structure and the drainage. That's what the cases say. You have to understand, the ballast is not just there for show. It provides a critical function for the
I
thing.
understand.
And so they're saying, no, you don't get to fuss with it.
In 100% of the cases, any kind of walkway built on a ballast, this is what those cases are saying. Per se, a walkway on top of ballast will affect the support nature of the ballast, and therefore you cannot do it.
There are cases that talk about that the cases that I just talked to all say, yes, you cannot require a state regulation. Yes.
Because it's always going to affect the ballast in every single case.
Well, that is the concern, right?
Yes, but that was
I don't know that they have all made independently the engineering determination is, but that is certainly that. But the
I understand.
issue is the scope of the preemption.
Pick one specific case that contains the precise holding Judge Kessler just articulated.
The
Precise holding Judge Kessler just articulated, which is that any requirement of a walkway on ballast anywhere in the United States is prohibited.
says we will allow plaintiff to pursue his ballast-related claims.
Site.
It's the Brenner versus Conrail case. We will allow plaintiff to pursue ballast-related claims only to the extent that plaintiff's claims relate to ballast being used completely separate from where track support, stability, and drainage are concerned. What we talked about was
That's the closest language you have to saying all regulations requiring walkways on ballast are preempted? That's pretty oblique.
let's see. Well, let's go to the Nichols language. The cases all just talk about walkway specifications are precluded because it would require railroads to enlarge the track support structures beyond federal requirements. That's Missouri Pacific.
Okay. I think you've answered the question.
And well, the last one is walkways are part of a, let's see, they are immune from further regulation by state agencies. So,
Okay.
thank you.
Thank you very much. Thanks to both counsel for your arguments. The case is now submitted and under advisement. We will issue a written decision in due course, and the court stands adjourned.